chief judge that you mentioned, Judge Boasberg, has written, and I'm quoting him here, Federal Rule of Criminal Procedure 6E allows witnesses like Patel to divulge the contents of their testimony, meaning that nothing was preventing him from doing so before the committee.
The Chief Judge of the United States District Court for the District of Columbia wrote that about Kash Patel by name after Patel sat before this committee and implied a court order was blocking him from speaking. The judge said there was no such order. Nothing was blocking him. And today, Senator Whitehouse walked back into this room with that document and put it directly in front of the FBI director.
Director Patel, welcome.
Thank you, sir.
What you are about to watch is a Senate hearing where a sitting FBI director was confronted with the written words of a sitting federal judge, words written specifically to correct something Patel said in this same room during his last visit. The open question, the one this hearing never fully closes, is whether Patel misled this committee about a court order that did not exist, or whether there is an explanation that the record does not yet contain. By the end of this video, you will have heard everything the record does contain, and you will have Patel's own answer, under oath, for what happened to the grand jury transcript he said had been released. One word. We will get to that word, and when we do, you will understand exactly why Senator Whitehouse said he would be checking on it.
When you were here for your confirmation, we talked about your so-called enemies list. It appears to me that there have been adverse actions of various kinds taken against about 20 of the 60 people on your enemies list. You've been in office for 7 months. At that rate, you've got 14 months until you've hit all 60. Can you explain that?
Senator Sheldon Whitehouse is a former U.S. attorney and a former state attorney general. He opened with arithmetic because arithmetic does not require argument. 20 adverse actions, 60 names on the list, 7 months in office. The rate produces a number, but the enemy's list was not the bombshell he came to drop. It was the setup. He needed Patel on the record defending the process before he brought out what Judge Boasberg had written, because that question was going to land much harder after Patel had already committed to his story.
Again, that is an entirely inaccurate presupposition. I do not have an enemies list. You can continue to characterize it as you wish. The only actions we take, generally speaking, for personnel at the FBI are ones based on merit and qualification and your ability to uphold your constitutional duty. You fall short, you don't work there anymore.
He denied the name. He did not deny the math. He did not say 20 people have not had adverse actions taken against them. He denied the label and pivoted to standards and qualifications. And notice the confidence in that response. Patel is comfortable here. He has given this answer before. He knows how it plays. Senator Whitehouse let it land, and then he opened the file.
Well, there was a list. You don't like it to be called an enemies list, and it had about 60 names, and about 20 have had an adverse action. So those are, I think, pretty clear facts. Let me move on to your grand jury testimony, which we also talked about when you were here. I think you indicated that you understood that a witness in the grand jury is free to discuss afterwards whatever they told the grand jury. And you then went on to suggest, saying, I can't go into court orders granted by the D.C. District Chief Judge, and you want me to violate a court order. In those remarks, you fairly plainly suggested that there was a court order of some kind that somehow restricted or limited your ability to discuss your own testimony to that grand jury. Since then, that chief judge that you mentioned, Judge Boasberg, has written, and I'm quoting him here, Federal Rule of Criminal Procedure 6E allows witnesses like Patel to divulge the contents of their testimony, meaning that nothing was preventing him from doing so before the committee. Can we confirm here today that there is no court order of any kind that limits your ability as a witness before the grand jury to discuss your own testimony to that grand jury?
Stop right there, because that is the bombshell, not a theory, not a political accusation. The Chief Judge of the United States District Court for the District of Columbia wrote a public correction, naming Patel specifically, saying that nothing blocked him from speaking to this committee, not a court order, not Rule 6E, nothing. And what Patel had told this committee previously was that he could not go into court orders, and he did not want to violate a court order. The plain meaning of those words is that a court order existed and constrained him. The judge said no such constraint existed. One of those statements is wrong. Senator Whitehouse had the judge's words in hand. Now he needed Patel's answer.
We can confirm that pursuant to my action that grand jury testimony has been released, the transcript.
Let's, in what forum was it released, may I ask?
Publicly.
One word, publicly. No link, no date, no filing number, no docket, just publicly. Senator Whitehouse said he would check on it. That single word now sits in the official record as Patel's sworn answer to where the grand jury transcript lives. The committee will find it, or they will not. If they do not, a question for the record is already prepared. But notice what Patel did not do. He did not address whether a court order existed. He said the transcript had been released and moved past the core of the question. The question of where that transcript actually is remains open.
Okay, we'll check on that. The FBI does background investigations. In the case of a U.S. attorney, Jeanine Pirro, it has come to light that in a civil proceeding, that Fox News executives, prior to her confirmation, called her, I'm quoting here, a reckless maniac who makes, quote, insane comments, and said, I don't trust her to be responsible, and noted her penchant for what they called random conspiracy theories on weird internet sites. My question to you is, did that turn up in her background investigation?
Fox News executives, in a civil court record, not opposition research, not anonymous sources, a court record describing a Trump nominee for U.S. attorney as a reckless maniac who makes insane comments, who cannot be trusted to be responsible, who follows random conspiracy theories on obscure websites. Background investigations exist specifically to surface this kind of information before a nomination is confirmed. That is the entire institutional purpose of the process. And Whitehouse asked the simplest possible question. Did it surface here? Patel's answer did not get close to yes or no.
For any background investigation, Senator, we do not discuss those publicly. And for every background investigation, when there's adjudication, it is not made by me. It is made by the career professionals who run the inspection division.
Career professionals, inspection division, adjudication. These are real words that describe a real process, but they do not answer the question. The question was not who makes background investigation decisions. The question was whether a specific piece of information, Fox News executives calling a nominee a reckless maniac, turned up in the investigation of that nominee. And because Patel would not answer it, Senator Whitehouse did what a former prosecutor does when a witness will not pick an answer. He listed every possible answer for them.
Do you know if that information was found? You see, we're an oversight body here, and there are really three possibilities here. One is that the FBI background investigation didn't find that stuff. That's worth noting because these investigations, full field background investigations, are supposed to find that stuff. That's possibility one. Possibility two is that the FBI did in fact find that information and then did not report it to the administration or to the committee. And the third is that you found it, you reported it to the administration, and they went ahead with her nomination knowing that she had been described as a reckless maniac who made insane comments, who wasn't trusted by colleagues to be responsible, and who had a penchant for random conspiracy theories on weird internet sites. Are you saying that this committee does not have any authority or reason to look into which of those things is true?
3 options. Every one of them is a problem. Option 1, the FBI's background investigation system failed to find publicly available court testimony from Fox News executives, a systemic failure of the most powerful investigative agency in the world. Option 2, the FBI found it and did not pass it up the chain. That is a suppression question with serious consequences. Option 3, it was found, reported, and the administration proceeded with the nomination anyway, meaning someone reviewed that information and approved the nominee despite it. There is no 4th option. Whitehouse eliminated every exit, and Patel's response confirmed that he would not choose any of them.
This committee can look into anything it wishes. I'm telling you that the background investigations that are done by the HRD division are done by career individuals. They do not report the details of those to me. They adjudicate those independently and individually. That's how it's always been done.
He did not pick an option. He acknowledged the committee's authority and returned immediately to career individuals and the HRD division. The 3 possibilities remain open, unresolved, on the record. And here is where this connects back to the grand jury question. Because in both cases, the Boasberg correction and the Perot background check, Patel's strategy is identical. When the record contradicts what he has said or implied, he does not address the contradiction. He names a process. He names career professionals. He points to institutional structures, and he moves on. Senator Whitehouse was about to show what happens when that strategy runs into 8 specific calendar days.
What happened during the pause of FBI background investigations that was alleged in the complaint against you and the FBI by the FBI agents who were terminated? On February 12th, Emil Bovee directed the FBI, quote, to pause any FBI background investigations of Trump nominees until Patel was confirmed, which happened on February 20th, is the general description of what they alleged. Why, do you know, were background investigations paused? Was it so material like this could be scrubbed out of them?
8 days, February 12th to February 20th. A formal complaint filed by FBI agents who were themselves terminated, alleges that a specific named individual directed all background investigations of Trump nominees to be paused during that window. The dates are documented, the names are in the complaint, and with the Jeanine Perot situation sitting on the table, the question of what happened during those 8 days now carries the weight of everything Whitehouse has laid out in this hearing. Was the pause ordered so that information like reckless maniac and insane comments could be removed before investigators completed their work? Patel answered for the period he controls.
I can speak to the time period since I got there. Background investigations have been ongoing across the board at the FBI.
Why was the pause, do you know?
I was not there.
I was not there. Technically accurate. Patel was confirmed on February 20th. The alleged pause ran from February 12th to February 20th, so in the most literal reading, he was not yet FBI director during those 8 days. But Senator Whitehouse's next question was not about what happened before February 20th. It was about what happened immediately after. Because when a new director walks into the most powerful law enforcement agency in the country, on day 1, there is a briefing, there are transition documents, there are things the incoming director is told about what occurred in the days before their arrival. An 8-day halt on all background investigations of the president's nominees is not a minor operational detail. It is the kind of thing that gets mentioned.
Wasn't explained to you when you got there? Oh, by the way, boss, they've had an 8-day pause on background investigations. You think that would be something that would be explained to you at some point?
Again, I leave it to the men and women at the HRD division to run background investigations. I do not interfere with them.
I get that. But what I don't get is whether you were told about that pause, and why would you not be told about that pause?
I don't recall that, sir.
Compare those two answers. I wasn't there is about the period before his February 20th confirmation. I don't recall is about what happened after he arrived. Those are different positions. A man who was not told about the pause would say, I wasn't told. A man who cannot say that says, I don't recall. Under oath, in a formal proceeding, I don't recall is the specific phrasing used when a person cannot say no, but cannot afford to say yes. Whitehouse noted it and moved to his final subject, the most direct constitutional allegation of the day.
The allegation also relates that part of the employee review of senior staff was whether or not they voted for Kamala Harris in the 2024 election. Since when is who you voted for a proper question for agents to be asked?
I don't know what allegation you're referring to, Senator. If it's from an ongoing matter in litigation, I can't discuss that. But what I can discuss is I can only speak to mine.
So just to clarify, I'm not talking about the FBI full field background investigations. I'm talking about internal employee reviews for promotion, for termination, for job actions of various kinds. And my question to you is it now the policy of the FBI to ask agents who they voted for, and since when is who agents voted for a proper question for the FBI to ask?
Taking those in reverse order, it's not a proper question, and it's improper to allege that I'm doing that. And also at the FBI specifically, under my leadership, we do not ask who you voted for. And
he conceded the principle. It is not a proper question. Under his leadership, agents are not asked who they voted for. But notice what he did not say. He did not say the allegation is false. He said it is improper to make it against him. The agents who filed the complaint, the same agents terminated on February 12th, 8 days before he arrived, allege it happened inside specific internal reviews before his confirmation. The same 8 days, the same complaint that contains the pause allegation. Patel called the allegation improper. He did not call the agents who made it liars. A former prosecutor notes that distinction for the record.
Okay, I'll accept that correction. And in the event that we cannot locate your grand jury transcript, just expect a question for the record that will give you the chance to either provide that transcript again if it had been previously provided, or to make the statement that Grand Jury Rule 6E allows you, to the best of your recollection, truthfully, about what it is that you told that grand jury. Do you understand that?
No theatrics, no raised voices. Senator Whitehouse accepted a minor technical correction and told Patel exactly what comes next if the transcript cannot be found. That is the closing move of a former prosecutor who has already built the record he came to build. Now, close the loop that was opened at the very beginning of this video. The Chief Judge of the United States District Court for the District of Columbia wrote publicly that nothing prevented Kash Patel from discussing his grand jury testimony with this committee. Patel had previously implied a court order constrained him. The judge corrected that implication by name. Today, when Whitehouse put the judge's words directly in front of him, Patel did not address the contradiction. He said the transcript had been publicly released. One word, publicly. No link, no date, no verification. And the rest of this hearing, the reckless maniac, the 3 possibilities, the 8-day pause, the Harris vote question, all of it exists in the same record that now contains Judge Boasberg's correction. 4 subjects, 1 strategy from Patel across all 4. Name a process, name career professionals, and do not address the specific thing the record says. Senator Whitehouse built his case. He put it on the record, and the record does not expire. A federal judge wrote it by name. Patel said 1 word. The record holds both. What would you have asked him?